Thank you, and over to Steve.
Thank you, Kathleen. And welcome everybody to the Hemposium stream element part of MardiGrass. As Kathleen said, there's a whole lot of speakers on a whole lot of topics lined up for the rest of the day and most of tomorrow until the rally, up until the rally anyway. So yeah, join in and have your say. Part of what MardiGrass is about is expressing the frustration plus that we all feel about the way the drug laws are exist and are applied. Also, I'd like to acknowledge that we are here on Bundjalung land, of course. Always was, always will be, and always worth remembering that. And it's a very important part of MardiGrass that the Indigenous folk, the Indigenous people who used to live around here and still live around here, are appropriately recognised and honoured, and hopefully MardiGrass continues to do that. Usually what we do, as Kathleen said, I've been doing this session for quite a few MardiGrasses, don't count them. And what we generally do is a bit of an hour or so session about me telling you a couple of things about basic law, and then largely having a Q&A session. So just whatever questions you might have, I'll do my best to give you an answer about how the law works. The main focus is kind of meant to be really on legal advice, that is what the law is, not what the law should be or whatever. But inevitably we drift into discussion about why the law should change and how it's not very fair, and all the things that in a sense we probably already know, but the detail is worth talking about, and the politics of it is worth talking about. Anyway, so there'll be a bit of commentary, but really the intention is to empower people. The more you know about the law, general proposition, the more you know about the law, the more likely it's going to be impact you the least, I suppose. And broadly speaking, the more you know about the law, the more you know what you're allowed to and what you're allowed to do, what your rights are, what your obligations are. Good stuff to know. Anyway, if only the law could be respected in every aspect. It can't be, can't it? Because that's the trouble with the drug laws. The general proposition about cannabis, general law is it is illegal to do anything with it. It used to be a fairly straightforward proposition, and when I do these kind of talks, I often start out with just the general statement that it's illegal to possess, grow, sell, ask to buy, all sorts of activities, any activity, grow the stuff, any sort of activity around cannabis is illegal. A little bit less complicated, more complicated, but in a good way now, is that there's quite a few people who are able to obtain a prescription for medicinal use of cannabis. I don't know what the numbers are, but it's in the tens of thousands, at least in New South Wales. So it's not just a small number. For a lot of years, it was a theoretical possibility you could get a prescription. For many, many years before that, it wasn't even possible at all. And most of us looking into the darkness probably here remember those old days. But as time has gone on, there's been some loosening around the access to medicinal cannabis. It's easier for doctors to prescribe, easier to get a prescription, and leaving aside the arguments about how much the use of cannabis should be medicalised and controlled by health professionals, etc., leaving that to one side, it has meant that there are now tens and tens of thousands of people who are legally able to possess cannabis. How they find it is up to them, so there's no laws around lawful supply, etc., to medicinal users, except through the doctor. So what that means is if you're in the happy position of having a medical prescription, you are allowed to use cannabis and possess it, etc., but only in terms of the prescription. It doesn't mean you can go down, go to a barbecue and a mate will say, oh, here's this really good weed, have half a bag. Oh yeah, thanks matey, I'll take that home and smoke that. That is not covered by the prescription, okay? So that use of cannabis would not be legal. It's important as more people get prescriptions, it's important that you know that, because if you are in the unhappy position of being asked questions or under any kind of suspicion by police, the fact that you have a prescription might mean they don't take it any further, but it also does not necessarily mean that, and quite a few people are being busted with prescriptions in possession of drugs that they have not obtained through the appropriate lawful channels, and they are guilty and are found guilty of that. So I suppose in a practical sense, it comes back to the good old standard defence lawyers' advice to people is don't speak to the police. If you have the right to silence, one of the most important rights that people have in the criminal justice system, in the legal system, is the right not to have to tell anything to the authorities. If you're under suspicion, if you're under arrest, doesn't matter. You don't have to say anything. Give them your name and address, but the more you speak to police and the more you have a conversation with police in many situations, the more it is that you can talk yourself into trouble. Sometimes you can talk yourself out of trouble, but my experience is that people's self-estimate about how good they are at talking themselves out of trouble tends to be inflated, and they get it wrong a fair bit of the time. Yeah. Just a reminder, we need the mic, please, if you want to ask a question. Happy to be interrupted and ask a question any time, but if you could just remind people we need to use microphones, please.
Yeah, sure. Yes, Steve, just wondering, like, when you're talking about troubles with police, when police go too far, it's like, where do we stand?
Define too far. If the police act illegally, then you can theoretically have them charged and investigated for a crime. Usually what I think people understand by the police going too far or that kind of activity is not that they're outright illegal, it's that they have exceeded their authority and therefore they have not been exercising their duty by going past what their authority and their duty are kind of connected to each other.
Yeah, so
really.
all of that multiple times.
A lot of people's experience with police around the drug laws, and around other laws probably as well, but around the drug laws is fraught really with all that sort of what's hanging over the person, the individual citizen, is the threat of a punishment of some sort, jail maybe not jail, but at least punishment in the sense of fines and having to go to court and all that sort of drama. So the police are meant to behave the same way that we're all meant to behave, that is within lawful frameworks. If they don't, you can complain to the Ombudsman. You can make a complaint to the police if you think that what something did was illegal. You can make a complaint. They'll very likely say thanks very much and see you later, of course. But anyway, in all honesty, the effectiveness of the Ombudsman is limited, and it's probably a good thing that they're there, but it doesn't really have a significant impact on police culture. I think really. In a broader sense than the drug laws themselves, the police have power essentially because they are enforcing laws. Laws around not killing people, fair enough, that should be enforced. Laws around violence, fair enough, they should be enforced. I think we all have some common ground about that.
No, it's Steve, when they're
in every aspect of police enforcement, they go too far, right? Sometimes.
And so our recourse.
Sorry.
Our recourse.
Well, sorry, what I'm saying is really, in a long-winded answer, is our recourse is a complaint to the Ombudsman, okay? Or if the case goes to court and the police misbehaviour is associated with the collection of evidence, okay?
Okay, so me going to the Ombudsman doesn't take away from the fact that I just got out of prison and I was 6 weeks in maximum prison, right? Maximum security prison. Wrongfully incarcerated because for the last 2.5 years I've been trying to report police harassment of myself and my legal rights and many other cases that some of you are aware of, right? And that's been shut down at every point, Steve, and now I've been incarcerated and it's like I've got out and the thing is, it's like, oh yeah, go to the Ombudsman. It's like, try doing that from prison. You can't do anything like that from prison. So where's my justice? You're the law guy here. I'm just asking, Steve, where's the justice here? Not just drug laws. I'm talking about the overly oppressive nature of the state that we live in, and that the legal fraternity and, dare I say it, the the entire justice system, in inverted commas, and that's police, whether you call it legal aid in certain ways, shapes or form, also, you know, the DPP, and to an extent the judiciary, and all the way through to the incarceration system.
Can I give you? Thank you,
Steve. You're the legal guy. Where's the justice in telling your story?
Yeah, thank you for the question.
Can
I give you two answers? Can I give you two answers to your question? The first thing is that, of course, I sympathise with your experience you've clearly been through in terms of the last 2-3 years of your life, and possibly before that. I can't tell you anything about that because I don't know what the details are, and I can't give you any legal advice about that. So I won't attempt to do that. And of course, we're probably not the right place to be having that conversation anyway. But the second thing is that I agree with you. I'm a lawyer. I work in the legal system. I don't think it's just. I don't think it works all that well a lot of the time, right? I agree. Mate, please. One of the reasons that we're talking today about the drug laws is the particularity of how unfair it is that some people's choices about whether they do something or don't do something that might or might not be good for them health-wise, should that be the subject of laws? Should that be the subject of enforcement by, 19,000 police in New South Wales who have all sorts of guns and helicopters and cars and all sorts of things? Is that the right way to do things? Is that the right approach? And I think the reason we have MardiGrass for what we're up to the 31st time this year is because for a long, long time we have been attempting to change those laws. Because the system, the legal system, criminal justice system is not perfect, is not fair, then the more we keep it out of people's lives, in my view, the better. The law around possession of cannabis, hang on, mate, this is not, please don't call out, because I can't hardly hear you. I'm going to keep talking over you anyway. Everyone around you will hear you, and it's not going to work, okay? So I'm happy to have a chat to you afterwards when we finish. We're going to go for about an hour or so. Happy to have a chat to you one-on-one.
I agree, Steve. It would be great if you could just continue this discussion with Steve after, so we'll just move on, and thank you so much. Thank you.
So it's an offence to possess cannabis. It's an offence to supply cannabis. It's an offence to grow cannabis. It's an offence to do those activities. The elements, though, of the offence, what it really means in legal terms, what the court has to be satisfied is in terms of possession, the legal elements are you have to know that you have something in your possession in the ordinary sense of the word, that is in your pocket, for example, or under your control. In a locker, for example, that you have the key to. If you know there's a stash of drugs in a locker that you've got the key to and the police find out about that, then you are guilty of the possession of those drugs. If the quantity of the drug is over depending on the drug, the legislation sets out a table of different quantities for different substances. In the case of cannabis, if it's over 300 grams, you are presumed to be in possession for the purpose of supply of that drug. So the charge is supply. Whether, that's called a deemed supply. On a deemed supply, the police have to prove that you had possession, and then the legal presumption it was for the purpose of supply unless you can prove yourself that it was not for supply. So that's an example of how particular laws operate. So the police have to gather evidence about all of those elements of the law. So it might be pretty obvious that if there's cannabis in your motor vehicle, in your car glove box, it might be pretty obvious that it's in your control. But if you don't know that it's there, or the police, more importantly, the police can't prove that you knew it was there, then you're not in possession, legally speaking, or at least the police cannot prove. So when confronted by police, the temptation might be to say, yeah, that's mine. If it's in your pocket, you're walking down the road, you get searched, okay, it probably is yours. if it doesn't belong to you, but it's in it doesn't matter who owns it. If it's in your possession, in your pocket, and you know that it's in your pocket, and you know it's a drug, that's enough. Okay. Again, the more you tell the police that you use something, oh yeah, that's mine, it may be something they cannot prove. Okay, it just may not be. Lawyers are useful sometimes. If you get busted, you go to court. A legal aid lawyer, maybe a lawyer you engage yourself for a fee, will give you advice about it, and it might be that you plead not guilty and you've got a good case and you get off. You've got to go through the process of a hearing and so on, but that could be. It doesn't have, on the other hand, if the case is pretty strong, I'm a lawyer, I've been working as a lawyer for I don't have a long time, often the advice is you're going to be found guilty. A plea of guilty is the right approach. You get less penalty, it's over and done with quicker, particularly if you've got a good record. Anyway, so a plea of guilty means you get less of a penalty. It's a useful option. You should always think about it. Should always think about in the legal system whether things are right or wrong, fair, unfair, just or unjust. If you are on a criminal charge, absolutely should get legal advice about it. But if you say nothing to the police and they charge you anyway with, say, possession, you can go to court, plead guilty on the first day you're before the magistrate and get exactly the same leniency that you would get from fessing up to the cops and telling them everything and blah, 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 blah. Yeah, that's mine. I grew up myself, there's good stuff, isn't it? They get a warrant, they go home, find 10 plants in your backyard, more charges, more serious charges. The higher degree of activity, I suppose, around the production of the drug. So growing cannabis is more serious than possession. Again, there are sort of levels of how many plants becomes sort of super serious. Overall, there's a fair bit of common sense, I suppose, in a way. The higher the quantity of the drug involved, the bigger the penalty. So the maximum penalty for activities around cannabis is the supply or cultivation of the large commercial quantity of the drug, and that's about 25 kilos of leaf, of head, and 1,000 plants, I think, I'm not quite sure. I think over 1,000 plants. So we're talking sort of reasonable involvement with cannabis on a fairly big scale, it's got to be said, but the maximum penalty is 25 years for those offences. Ordinary kind of everyday case, 150, 100 plants in the local court, first offence, probably a good behaviour bond would be the result of that. For that would be what you'd expect. If it's a multiple offence, not your first time, certainly jail is possible. In the local court, the magistrate can only sentence you, this sounds an awful way of putting it, but the maximum they can apply is a 2-year sentence. Even if the maximum penalty for an offence might be, say, 10 years, assaults and so on have that maximum penalty. The longest jail time a magistrate can give you is 2 years in the local court, or if there's multiple offences, 5 years. If there's a whole lot of offences, 5 years in total. If the case is more serious above certain thresholds, there's just sort of, above this number, etc., of plants, etc., the case might go to the district court, judge and jury trial, and then the maximum penalties are the maximum. There's no limit on what the judge can do in the district court if you are unlucky enough to be charged with a serious indictable offence. Cultivation involves growing the plant. You can be in possession of plants if you know that they're on your land and you know it's cannabis. You didn't really think it was tomatoes. Then you're in possession of the plants, and that's sometimes all they prove. So the last 10, 15 years or so, there's increasing numbers of charges of possession of plants rather than cultivation of plants, because they don't have to prove you grew it, they just have to prove that it was in your place and you knew about it. Okay, driving. The other thing to talk about on front of everybody's minds in many situations, probably this situation we're in right now, is the driving laws around the use of drugs and cannabis in particular. It is an offence to drive a vehicle in New South Wales and every other state with the presence of THC in your saliva or blood or urine, but they only test for saliva. The offence is proved by the police proving that you were the driver of the car, truck, motorbike, and you had THC present in the sample of the saliva they take from you and take off to a lab. It doesn't matter if there's any impairment or not, and the argument's been raging probably for many, many years about how unfair it all is, and it doesn't impair, but it doesn't matter. The offence is proved simply by proving the presence of the drug. You get a one-page certificate back from the police laboratory, government laboratory, that just has some details about the name of the person and the sample number, etc., etc. The analyst who did the testing, just with a line that they fill in, present was THC. It's hard to know how long THC hangs around people's system. It can be days and days and days. Certainly the courts have the experience very frequently of people being charged with the offence and telling the magistrate that they had a smoke the day before, 2 days before. Because the offence is not about the actual use of cannabis or possession of cannabis, there's no kind of drama in a sense about telling the court that you had a smoke the day before. You don't get charged for that or anything like that. You don't get sort of busted for that. But basically the magistrate says, okay, well, it could be right. Doesn't matter, you're driving, and fair or unfair, you now are subject to the penalty. If you do not get convicted, you do not lose your licence. Simple thing. You can be found guilty of an offence, a driving offence, that would lead to disqualification of the licence if on conviction. A lot of the driving laws are expressed that if you're convicted of this particular offence, you must be disqualified for a minimum of so many months or years in some cases. But conviction is a status that does not necessarily follow from a finding of guilt. The magistrate can find you guilty and decide not to impose a conviction because of your good prior record, or the offence is trivial, or for a number of other reasons that are pretty limited. So that's one way of avoiding your losing your licence, which is clearly a very big impact on people, and particularly in places where we live and love, around the Nimbin area, the North Coast area, country area generally. There's no public transport, of course. You can't do anything without a car, pretty much. So if you've got a good driving record, you might get a Section 10, which is no conviction recorded, but you can only get that once in a 5-year period. So if you are lucky enough to get a Section 10 on driving with presence charge, which you might or might not, they're not automatic, but they're not uncommon, put it that way. Most magistrates will accept that there's probably no real harm being shown by any behaviour, because the police always just say, stop the person randomly, they did the test, no impairment noted, okay. So it's a pretty nuisance thing. There's some talk about whether people with prescription cannabis should be allowed to drive without that law impacting on them, and that is under discussion, it's been under discussion, and I think it's more likely to happen in Victoria than anywhere else. Possibly might happen here in New South Wales, but not in any time soon. It's one of those things that's the new government seems to be very cautious about doing anything about drug laws. They're going to have a summit sometime, don't know when, but I think when there is a drug summit in New South Wales, maybe next year sometime, I expect this will be a big recommendation. I think the government might pick up this one in a couple of years from now, but don't hold your breath, peoples. That's kind of what I wanted to cover in terms of general information. The always excellent publication at MardiGrass, the Pot Papers, which is the program and so on. It's got lots of information about cannabis. Always good, for free. Pick it up, grab one. You'll probably grab 4 or 5 over the weekend. People tend to pick them up and put them down and pick up another one. Anyway, On page 15, there's a page or so of legal advice and legal information about how the laws work and penalties and so on. So have a look at that. It's a very short, succinct, to the point legal textbook about the drug laws of New South Wales. I'll just throw over questions in 1 second, but I'm just also going to make the comment that we're in an unusual position. Normally there's a few people from Queensland here, yay Queenslanders, and there's usually a fair bit of sympathy for Queenslanders because over many, many years the laws in New South Wales have been a little bit less harsh, wouldn't say better, but a bit less harsh than poor old Queenslanders have to endure. And now the Queenslanders are winning the race towards more sensible drug laws with the announcement a few weeks ago that they're going to allow a 3-caution system for possession of all sorts of drugs, small quantities, personal quantities. So it's encouraging that at least people in other places are getting some relief from the ridiculous laws, and encouraging that at least some politicians and some governments are willing to take at least some steps towards getting rid of this nonsense that's called prohibition. I talk a lot because I'm a lawyer, I talk a lot because there's lots to say, but also happy to take any questions or comments from the audience. But please, as a reminder, just put your hand up, we'll get the microphone to you, and away we go.
Here we go.
Yeah, Steve, when they say random drug testing, but they put a vehicle on all of the entrances to this village, is that still considered random?
Yes. The law is really about that the police are entitled, lawfully, to stop a driver for the purpose of conducting a breath test for alcohol, or to stop a driver for the purpose of conducting a saliva test for the presence of THC, cocaine, methamphetamine, and what's the other one? I don't know, forgotten. Yeah, it's not opiates. Opiates are not covered. Anyway, the word random is a bit misleading. It doesn't have to be, close my eyes and throw a dart at the dartboard and IKU. It can be for no reason. Just means it's for no reason, okay? They don't need an excuse. You don't have to drive through a stop sign or something for them to pull you over. If you do drive through a stop sign or you are speeding or whatever, then routinely the police will do a breath test, and sometimes they'll do a saliva test. So if you stop because you're going 10 k's over the limit, happens to most of us, be prepared for a breath test, but only some of the time, a saliva test. So just adding to that, there was a case recently where the police told the court, this is a local case, so I know about it, not particularly surprising case in a way, but the police pulled over a car because they wanted to search them. They kind of knew the people, how does this happen? Anyway, the police knew the people, wanted to search the car. They had no particular suspicion about anything, but they told the police they pulled the car over to conduct a breath test and then decided to search. But they didn't do it. Well, they did a breath test, but that wasn't the reason they pulled him over. Anyway, a bit of a long story in a sense, not really. So the court threw out the evidence of the search because the reason that they had stopped the car was not for the purpose of doing the breath test, but for another purpose, and therefore it was not a lawful reason to stop the car. Therefore, everything that flowed after that was unlawfully obtained, and the evidence was not allowed to be introduced to the court. So there are kind of all sorts of situations that come up, I suppose, around and about interaction with police in terms of traffic laws.
Steve, what about contamination of evidence and what have you? I mean, the police, for example, are wearing gloves. If they're not changing gloves between tests and what have you, is that a defence that you've used and any success?
Look, it's probably good the police aren't involved in nursing or other health professions in some ways because they're pretty slack about the gloves thing. It's possible that substances could be contaminated. The procedure, it's worth going through the procedure in a bit of detail. The procedure is they do a swab of the driver, okay? That swab is just an indicator. Is there a drug present or not present? Okay, it takes whatever, 5 minutes or thereabouts. The line turns up or it doesn't turn up on the indicator panel. They just throw that away. That is not anything, right? If it's a positive swab, they take you back to a bus on all approaches to Nimbin this weekend, or a police station, and they take a sample of saliva, swab your mouth again, take a sample, stick that sort of little lucky into the Dragar machine, a machine called a Dragar machine, and that gives you a reading, positive or negative. That sort of doesn't matter. If it's a positive reading, you're told not to drive for 24 hours, directed not to drive for 24 hours, to short-term suspension. If it's negative, you're just allowed to go. But either way, that sample, that second sample, first sample really, the swab is not a sample really, that sample is sent off to the laboratory and that's analysed, okay? The Dragar machine is hopeless, 50-50. There's just hope, well, why they, I don't know, it's just a nonsense in the nonsense in the nonsense, but anyway, just completely unreliable. 97% of the samples that come back are positive from the lab. Okay, when a proper scientist looks at it and says, yeah, there's something there, they run it through a spectrograph machine. I don't understand all this chemistry stuff, but they'd run through a machine, bulk analysis, of course, thousands of them, thousands and thousands of them every year, anyway. So the procedure is they're meant to take, dealing with that sample they take from you, wearing gloves at all times, put it into a sealed container, write a serial number or attach the serial number from the plastic sort of thing churned out, put the serial number on the container, sealed. It gets dealt with by the police system in terms of that's passed to someone, arrives at the laboratory. The analyst on their certificate says, my name is Joe Smith, I'm a pharmacologist. On this date I looked at sample blah, they write the number in, and I found positive, okay? So there's the potential for contamination if the cops aren't wearing gloves. There's the potential for contamination if they've been dealing with another driver 5 minutes ago who was positive and somehow that person's saliva got onto the sample. But in terms of just going to court and saying, well, they should prove that it was not contaminated, you're not going to get very far. Because on the face of it, there's nothing to really say that something broke down, okay? So this is one of those, this 31st MardiGrass nostalgia time. The very first MardiGrass, there was a famous, just interesting, funny case really, but just on that point about contamination in a way, in the chain of custody they call it. Bob Hopkins, who was one of the founders, I suppose, one of the old stoners who thought this was a good idea. There was an event at the Nimbin police station. A number of people, including Bob, went inside the police station smoking joints and said, arrest us, arrest us. So they arrested Bob, not completely surprising. Bob was not surprised. Anyway, he pleaded not guilty to the possession of the cannabis that he was smoking in the police station at Nimbin that they took out of his hand. When the case came to court, the police could not prove that they had passed that cannabis, that sample that they take, that joint they'd taken from Bob, from Officer A to Officer B to Officer C to the exhibits officer to then to the court. They had not done all the paperwork on the chain of custody. So Bob was happily enough found not guilty of the offence of smoking a joint inside the police station at Nimbin, but even though it was pretty good stuff apparently, because they couldn't prove that he had cannabis. Obvious as it would be to everybody else, but anyway, the legal system has its wonders. But it's, there was, in that case, the prosecution asked for the evidence. The defence asked for the evidence to be produced, that is for all the certificates and so on. They couldn't do it. If you want to go through the bother of challenging a driving case, you can. I've done it a couple of times. Their paperwork's pretty good. Okay? Their paperwork has been pretty good. So if you want to do it, you could. You could subpoena the records to prove that chain of custody, but it has not been a successful argument that I'm aware of, because they are pretty good about proving the chain of custody, and then you're just speculating whether there might have been some cross-contamination. If you have some reason to think there was cross-contamination, you saw the officer without gloves on, for example, you give evidence about that, right? But like I say, it's not, you wouldn't go very far just sort of trying your luck to say to the magistrate, they've got to prove it. They don't have to prove it unless there's real evidence that there's a doubt about it. Okay? Ah, there is a hand.
Steve, when do police actually have the right to search a vehicle?
Searches of people and vehicles are under the same rule, same law. That is, there must be a reasonable suspicion that the search would produce evidence of an offence. So that could be searching for house-breaking implements like crowbars and stuff if they think you might be a burglar. It could be looking for guns if they think you might be a gangster. It could be cannabis if they think you might be a criminal. It's really one of those self-fulfilling prophecy sort of things, really. Oh, we thought you might have had drugs. We searched you. We found some drugs. So we thought we were pretty right. It's not quite as simple as that. They have to have reason for it. But in many, many, many cases, because the drug's been found in your pocket or in your car, then people say, oh, look, I'm guilty. It's my stuff. I'm guilty. Okay? If you want to challenge it through the legal system, through going to hearing, it would be challenging the reason the police had for the search. Police would go into the witness box and tell the prosecutor in answer to a question, why did you stop that vehicle? Because it might be because they knew the number plate and the car had been involved in drug offences earlier. It might be the owner of the car, I should say, not the car. Cars aren't that guilty, are they? But the owner of the car is going to say. There could be all sorts of reasons why they had suspicion. They might not have liked the look of you. That's not enough, really. And they won't really say that. But they might say that there was something about your behaviour. It's a matter of just looking closely at every particular interaction. Unfortunately, maybe, or maybe it's a good thing, the legal system is about case by case by case by case. There's big, broad patterns of things, of course, but any particular case might be something a little bit out of the ordinary that is wrong. So it's from the point when the police, in terms of searching, when did they form the view they could search? What was the suspicion at that point in time? Having a successful search, finding drugs doesn't mean it must have been legit to stop you. Magistrates, I think it's fair to say, would be a bit predisposed to think, well, they probably, had it's sort of a little bit likely if they found drugs that they had a reasonable suspicion about it. And the test is a pretty low one in practical terms. So the police will say, oh yeah, we did it for this reason. That's why we thought it. The person looked suspicious. We stopped them about something and they looked suspicious. We stopped the vehicle for a breath test, which might be legitimate, maybe. And they could smell cannabis in the car, or the driver looked, nervous. And, why are you nervous, sir? Oh, no reason. No reason. Often they get away with it. But again, it goes back to that point about if you're charged with a criminal offence, or a driving offence maybe, in some cases, probably, as well, it really is worth getting legal advice about your particular circumstances. There might be something where they have gone beyond what they should do, behaved unlawfully, and then it's a discretion for the court if that evidence is allowed to be admitted. Sometimes it is, because it's in the interest of justice to introduce evidence, allow evidence, even if there's been some misbehaviour or misconduct by the police. Okay, we don't have to stay here. This is not school. If there's any other questions, here's a good time to ask it. If there are any other comments, here's a good time to ask it. The next session here is at 11:30 in this very same room, which is Fiona Patton, the excellent former Member of Parliament of Victoria, great friend of MardiGrass's, talking about how to influence politicians. So come back at 11:30, hang around the Hemposium all weekend, because there's stacks of good stuff. Good luck with your lives, good luck with driving out of here, good luck with getting home safely, and good luck with any interactions you might have with the police force in New South Wales or anywhere else, including Queensland. Yay, Queenslanders. Thanks a lot for coming.